A very warm welcome, good morning to all our participants, law students, law aspirants, legal practitioners who have joined us from different regions of Maharashtra for today's exciting Sunday Law Bulletin session. It's a great pleasure to have each one of you with us here today. As we commence with today's program, let us have a brief introduction about Lawyers Development Forum, which is LDF. So LDF is popularly known as the platform which is committed for nurturing growth, development, and establishing camaraderie within the legal community. Beyond inspiring interest in the field of law, LDF actively tries to bring together advocates through a blend of academic excellence and recreational spirit through different insightful lecture series and even energizing sports events like cricket matches and badminton tournaments. This forum fosters both professional development as well as a personal well-being. We also host conferences featuring esteemed judges and expert speakers, creating opportunities for a meaningful interaction and guidance as well as practical learning. Of course, this is our signature initiative, as you all know, the weekly Sunday Law Bulletin session. And here, specialists from different domains share their expertise, they break down their complex topics and encourage deeper engagement within the law. For this endeavor, we are particularly grateful to Advocate Dr. Rajendra Anbhule, sir, Founder President LDF, Advocate Vijay, Shelar, sir, Secretary LDF, Advocate Abhishek, Arvind, Jagtap, sir, President LDF Pune. Their vision and dedication continues to shape and strengthen this forum. With this, let us now briefly walk through our today's program schedule. We have an eminent guest speaker with us here today. It's a great pleasure and honor to introduce Dr. Rahul Kailas Bharti, sir. He will be delivering the session Admissibility of AI-generated evidence in Indian courts, legal standards and emerging challenges. He is a highly accomplished academician, legal expert, and a researcher with multidisciplinary qualifications including LLM, PhD in law, UGC NET, MBA HR, MSc in physics, and a diploma in civil engineering. He currently serves as the head of the Department of Law at the Government Institute of Forensic Sciences, Chhatrapati Sambhaji Nagar, Maharashtra, as a Class 1 gazetted officer under the Government of Maharashtra. Dr. Bharti is widely recognized for his expertise in cyber law, cybercrime investigations, digital evidence, AI and law, data protection and forensic sciences. He has authored several acclaimed books, including Cyber Law and Cybercrime Detection, IBR in Cyberspace, and Guides on India's New Criminal Laws and the IT Act. His research contributions include publications in the reputed Scopus and Web of Science journals, along with patents and copyrights recognized by the Government of India. He has trained police officers, army personnel, and professionals through prestigious institutions, including NILIT and law enforcement agencies. His excellence has earned him numerous national and international accolades, such as the Dr. Sarvapalli Radhakrishnan Distinguished Faculty Award, Global Cybercrime Helpline Award, Outstanding Scholar Award in Law, and a Distinguished Forensic Legal Scholar Award. Sir, it's a great pleasure and honor to have you with us here again today on this Sunday Law Bulletin session. We are eagerly awaiting for your session. With this, now I hand over the virtual mic. So you may now kindly continue. Thank you so much, sir.
Yeah. Thank you, Ruchiji, for my introduction. I hope I'm audible to all.
Yes, sir, you're audible.
Okay, I will share my PPT. Yes. I hope my PPT is visible.
Not yet, sir.
It is visible now, sir.
Yeah, okay. Check, maybe it's changing the slides because sometimes the problem came, but I will try.
Now it is visible. Everything's fine, sir.
Okay, slides are also changing.
Yes, sir. Yes, sir.
Okay, yeah. Good morning to everyone, distinguished colleagues, my students and future tech advocates, I can say, honorable members of the bar. I see my number of students are joined it, and number of the members of the newly elected members of the Bar Council also joined. I'm very grateful to the Lawyers Development Forum. My students Abhishek, Chinkita and Ruchiji also for again providing me a great platform to interact for the Sunday Bulletin every Sunday. So today I have chosen the topic which is because we are living in such a AI world. Topic is about the admissibility, about the AI generated evidence in Indian courts. What legal standards and emerging challenges are we faced? I hope today we all are today's morning is a very fresh morning, I can say, because we just win the democracy. Just we know, understand the voice of the Gen Zs. But this is not about the protest, about the political demands. But this protest, which happened since last month till date, is about the one of the digital era, digital evidence, electronic evidence, about the NEET paper leak case. Apart from the other angles, the questions came in every person's mind whether the evidences which are transferred from one platform to another platforms is really original, or it's an AI manipulated, it's a synthetic file, or what else. So that's why this topic is very important one, to understand the nuances, very nuances about the evidence, but the AI generated evidence in the AI era. Apart from another angle, recently in 2nd July 2026, the Supreme Court of the India, they did something, maybe you heard somewhere, you are reading somewhere else also. They mention in the one case, in Pooja Singh case, a bench of Justice Narasimha, they discovered that the NCLT, the Company Law, National Company Law Tribunal, they decided the whole insolvency matter, which are completely based on such a kind of a judgments, such a kind of a ratio, which is not yet existed. Means the court decided the matter which does not simply exist. Means it's a hallucinated citation, it's a fake citations. So they won. The Supreme Court of India in this case won to the future tech advocates. ChatGPT is not the already deciding authority. So in that context, the court demands zero tolerance policy for the unverified contents. And that's why recently the use of the AI draft regulations introduced for the suggestions. I am also providing a suggestions document. But this is also very important. Even BCI also coming with the ethical rules, AI ethical standards. What about the AI generated evidences? Number of these social media platforms are there. WhatsApp, ChatGPT. Social media intermediary, I can say. Intermediary. The word is intermediary now. Telegram. Most suspicious platform where the current NEET paper leaks is available. But how this evidence can be put forward in the courtroom, and what the court's opinion, what the law says, which are the laws are there, which are the rules are also there. So apart from, I will not go directly the scientific because we are the legal, but some touch about some forensic area also must be required in case of this area. I hope my audible to everyone. Am I audible to all?
You are audible, but sometime intermittently it is breaking up.
Yeah, okay.
Now it's fine, sir.
Okay. Now I changed the slides. Maybe it's visible.
Yes, and now you're on 6 parts, 1 argument.
Yeah.
Yes.
Yeah. Okay. So the structure, what we will discussed in the today's lecture. See, there are 6 parts, 1 argument. What means? If you see the legal frame, if you see the statutory frames, Indian Evidence Act, I can see it's an old law which directly targets on the electronic records, because currently we are moving from the traditional lawyering to the AI-based lawyering. So naturally, the court are flooded rather than the physical evidences. It's flooded with more with the digital kind of the evidences. Means if you want your electronic record to be admissible as an electronic evidence, requires some procedural requirements. So electronic record is a wider term. As per the IT Act, it's concerned, it's a wider term. It includes every, I can say it's every audio, video, multimedia files, which can be generated, which can be stored also. So the statutory frame for this evidence includes your Indian Evidence Act previously, where particular sections are section 65A and B. This too talks about the admissibility of the electronic records. They give the procedural aspects, what conditions are required when you submit electronic record in the courtroom as an evidence. So your record must satisfy those conditions mentioned under 65B. But now, from 1st July 24, we are coming from the pre-colonial era to our Indianized era. That is your Bharti Saksha Adhiniyam 2023, effective from 2024. The very section of 65B is replaced by another section, that is section 63 of the Bharti Saksha Adhiniyam. Is very important. Maybe some of the advocates are also, they are producing electronic record, they have to submit certificates. But what difference between this earlier Indian Evidence Act and the current BSA? We'll see that point up also. But this framework is important even in case of your AI generated evidences are concerned. Apart from this law of evidence or Bharti Saksha Adhiniyam, Information Technology Act 2000 is very important. IT Act 2000. In the very IT Act, section 79 capital A, which deals with the examiner of electronic records. This is one of the statutory frame. But apart from this frame, some rules are also there, like intermediary guidelines, IT rules are also there. Apart from some judicial interpretations are also there, as far as the admissibility and the condition precedent of the certificates while submitting any electronic records in the courtroom. From Navjot Sandhu's case, then Anwar case, the Shafi Mohammed case, and then the Arjun Khotkar case, we'll see the doctrinal arc. What the courts changed their own stance and came to the what the ultimate impact of the decision in Arjun Pandit Rao case. Then most important, your AI case, your Jaswinder Singh, then Anil Kapoor's case, rights, then Rajesh Sharma's case. We'll see the judicial interpretations, how the court can interpret and how they can admit, what the ratios are mentioned by the courts. Apart from this Indian context, statutory frameworks in USA, in UK, in European Union, and in Singapore. This is some important country which I have chosen to have comparative aspects in India with respect to the other countries. Apart from, even though everything, laws and regulations are also there specifically, but still some emerging challenges every day we faced. For example, defects, clone voice. Number of times in matrimonial, maybe husband or wife, they can produce a one voice note or recordings. So it's may possible other side of defense counsel can challenge directly. It's a defect, but is really defect or real? So maybe sometimes real looks like fake also. So for that we see one socio-political phenomenon, liar's dividend. I will try to link with this current NEET paper leak case as well. Black box problem. Currently, we all are facing, even the judiciary, black box problem. That's why the Supreme Court and every court can come up, lower courts also, with have some guidelines. And then we see, even though we have a section 63 of the Bharti Saksha Adhiniyam, even though they provide some changes as with the old law, some gaps are still exist. And then last part out of the 6 parts, we see the practitioner's kit, advocate's kit, cross-examination, authentication, and what the BCI ethics standards are concerned. This is what the overview of what today's lectures are concerned. I hope my voice is still audible and everyone's listening. I stay in the slide.
Yes, sir.
Yeah.
Yes, sir, I can see this.
Yeah. Now, why this matters? Why this concept is important in the current era? Because we are living in a cyber world, cyber space, which is a borderless space, imaginary world, unreal world. The word where cyberspace is itself is invented by William Gibson in Neuromancer. One of the novel is there. It's a borderless, unreal world. It's a borderless space. Now the questions can be, why this matter? Because currently everything is machinery operated. The machine is now becomes witness. Can we testify the machine? Can we cross-examine the algorithm? It is occasionally unreliable. the focus force about these multipliers are concerned, the whole recodification of the Bhartiya Saksha Adhiniyam mostly come from 24, and that's why they replaced the Indian Evidence Act by section 63 of the Bhartiya Saksha Adhiniyam, which replaced the section 65B. So currently, whatever the media generated files are there, for example, you can take any examples, any reels can be found to be in Instagrams. Suppose maybe sometimes our Honorable Prime Minister yesterday night between 12 to 1 o'clock, he wake up and he share the video clips to silence the voice of the Gen Z. Again, questions can came up in this deepfake era. Really, that particular, our highest function of is as a time to sit and share the screen and make a video. It's scam questions can come, whether it's a synthetically media or it's real media. Questions can come up. So synthetic media explosion is more. The share of a deepfake in global fraud attempts mostly from 0.1% to 6.5% increases. So 2,137% increase as per the put. Generative AI in Jaswant Singh versus State of Punjab in 2023, the bench and Indian court, they openly consult ChatGPT for the bail jurisprudence. First and warning shot. To say what, that's why the BCI, even the Supreme Court of the India, they try to draft the AI policy. Kerala High Court is the first High Court to draft the AI policy for the district judiciaries. So that's why for this regular patchwork is there by the MIT. Minister they draft the IT rules. July 25, Kerala High Court. In this very month itself, Kerala High Court draft a AI policy for the district judiciary. Kindly go through it. They completely ban the AI tools for the reasoning, legal reasoning. Judges are the ultimate arbiter and decider. So that framework is drawn, which we practice inside it. But the central question is still it. When a screen speaks, I mentioned in this language, when a screen speaks, whose voice is on the record? The witness, or the machine, or the model, or the large language models which we can see, whether it's Gemini, Midjourney, Cloudy, whose voice are there on record? So the certificate under 63 clause 4 of Bhartiya Saksha Adhiniyam, they try to answer the authorship of the file. They only give the answer authorship of the file, I can say, but not written to answer authorship of the content which are in the file. That's why I mentioned machine is now becomes a witness, but how we can testify? There is a points of issue here. That's why we go through that way now. Next slide. I hope slide is visible and my voice is audible to all.
Yes, sir. Yes, sir.
Yeah. Now, the title itself is Admissibility of the AI generated evidence. But what in general AI generated evidence means? Maybe we know that only the deepfakes, clone voiced. Maybe sometimes your client can show one of the video recordings and show the other opposite party make confession. The confession video is there, but whether the confession video is really a real video or synthetically generated media video or manipulated video. In simple sense, AI generated evidence means it's any information. See, it's not only record, but it's an output, it's an image, it's an audio file, it's a video file. Even the textual content which are produced, not only produced, but the transform, even inferred or synthesized. The word is come synthesized media. Recently, kindly go through the intermediary guidelines, which is recently updated. That guidelines, which is a digital media ethical code, they use the word specifically now synthetic media, which is like a artificially generated content. So all those information, if it can become from AI system, AI models, and they can be tendered before a court of law as a proof of fact in issue or relevant facts, then we can say those evidences are a AI generated evidences. In simple, only AI generated does not mean like an evidence, but when it used for the course of law as a facts issue, proof of facts issue or relevant fact. So these definitions cover, first thing is non-human authorship, means the content is authored, but it is stored or transmitted by a model, large language models. So there's no any human deponents are there. So how the opponent lawyer can cross-examine the content itself, if the content is came from the AI. If the tomorrow in the courtroom also supports, the counsels can argue for the courtroom, and you mentioned, your lordships, I cited this kind of the particular judgment and legal reasoning, which given by the AI itself. Can we provide AI as an authorship? What the court's opinions are there? Can, if opposite lawyer can mention, I want to cross-examine the large language models, is it possible? Can we cross-examine the algorithm? Can we cross-examine or testify the particular large language model? That is also one challenge. Second is the output is a probabilistic. The output is not a deterministic. So rerunning the same prompt, they may produce different results. You can check it. It's a fundamental departure from your traditional evidences, documentary evidences. When you put a documentary evidence, a primary, original document is a primary evidence. As per the old section 62 of the Indian Evidence Act, now currently section 57. Then third important is opacity of process. The chain, which from training data, how much weightage, inference, then why output resist conventional forensic inquiry. That is what the meaning of the AI generated evidence is concerned. Now we are moving to the next. I hope slides are changed and it's visible to all, and am I audible?
Yes, sir. Yes, sir.
Yeah. Now for the bench is concerned, for the legal fraternity is concerned, at least we must know this taxonomy. A taxonomy for the bench. Not all AI evidence is alike, but the burden, evidentiary burden, it actually shifts from category to category. So I categorize it 4, 5. Mostly first is your gen content. Generative content means text, when you directly generate text, image by giving a prompt. Audio, video files. Means output of the models are mostly synthetic photographs, morph images, deepfake, clone voice, which recently happened in the celebrity cases. Like in Amitabh Bachchan's case, like in Anil Kapoor case. That's why they come as a personality rights. Then GPT authored briefs also. Some lawyers can immediately, within some few hours, they can immediately use the GPT authored briefs. They prepare it. But even though after generating all the briefs, you cannot verify the content. So at least you have to verify those contents, whether those citations are there or not. Because just we have seen in 2026, recently in this month, in Pooja Singh's case, the whole matter of insolvency is completely based on such kind of the GPT authored briefs. And the Supreme Court warned a cautious approach. So there's a high risk of fabrications. Even the courts, it's not very easy to understand it's a real or fake. We'll see the dilemma also. Another angle, analytical inference, means scores and predictions. So these models particularly, they tell the court what it thinks. Means what model thinks. Like total fraud scoring, particularly recidivism predictions are concerned. Sentimental analysis are also concerned. Forgery detections are concerned, because court also now using, they are moving now to using such a kind of things for their day-to-day task. But I will come to the challenge also that way. Third is your biometric match. Very important. Facial, voice, gait, and iris. So AI Compass, they capture your biometric against a database. Like CCTV face match against a suspect gallery. Currently, 2020, the daily right investigation, that FRT can be used. Facial recognition technology can be used. Even in the current NEET paper leak protests and demand, political demands for resignations of the education minister, and that success. So in this also, even though the matter is silent, but the surveillance mechanism, Delhi police under the Minister of the Home Affairs, they deployed the FRT, facial recognition technology, to match which students are there in the protection do. It's against your privacy issue also again. Third is enhanced records. Means AI clean CCTV footage. You got the CCTV footage, but use the AI enhancement models or apps. Means you are making some changes. You are upscaling maybe audio or image file as well. So original recordings is real, but AI has what? Sharpened that video, scale it. So question is this still original then? If you are using any AI to making a, suppose any image you got through the WhatsApps and you want to produce in the courtroom with your brief. You see that that image is very blurry. That image is such an old photo, and you want to make somewhat only exposure, brightness. You use the app directly AI, putting upload a file. Questions came: is this original or derivative? Then that question is also one of the can affect the decision also. Next thing is autonomous machine logs. Means data which are created by autonomous systems, self-driving car, which comes with the number of the companies currently. Wearable health devices, which you are using the wearable devices to monitor your patterns, heart patterns, blood patterns. You check the BPs, number of walking steps. But that can be stored your data. Your digital privacy came into picture then. So this taxonomy for the bench, which kind of the content, which can be models they can be used, and how their evidence can be cited in the courtroom, we'll see that points. I hope slides are changing and it's visible, and am I audible to all properly?
Yes, sir. Yes, sir.
Yeah. The title of our today's lecture is admissibility. But before we ask about the admissibility, we know that in India, Constitution of the India is the supreme law of the land, basic law of the land. It's a grand norm in Kailas terms. It's the highest norm. Everything, every law can be checked with the touchstone of the constitutionality. So there's no exceptions to the AI era as well. There's no exceptions to the AI models, AI methods, AI surveillance mechanism, everything. So before, that's why I put a question that before we ask the admissibility, we must ask the constitutionality. Two important articles are very important. Article 20, Clause 3, which you also know about the self-incrimination. No person accused of any offense shall be compelled to be witness against himself. So, what Sylvie's case, you know, that involuntarily administrations of the forensic technique, scientific methodology, narco technologies, it's a violation of 20 Clause 3. It's a compulsion. It's a testimonial compulsion. It's a physical compulsion also includes your mental trauma. So does compel submission of a face print during or using a facial recognition technology, even in the current student protest which they deployed, without the voluntarily taking statements or consent from the students, voice samples, unlocking biometric to feed. It's violation of Article 20, Clause 3. It's very important. Most important aspect to your Article 21. No person shall be deprived of a life and liberty except procedure established by law. Fair trial mandate in confront and cross-examine. But in case of the black box problem, when AI model itself is one of the party, it's impossible to do a cross-examination of the black box algorithm. Our case, Puttaswamy's case, which informed the data protection dimensions, digital privacy, data privacy, Aadhaar Act judgment is very important. So if a facial recognition tools, they systematically suppose misidentify because there is no any such kind of a technology, there is a completely match. But there is some kind of an error rate. This facial recognition technology misidentify the persons of a darker skin, which happened in one of the case. Reliance on such evidence, it violates the anti-arbitrariness. Kindly read this with EP Royapat's case. Most important, Article 22, Clause 1. Right to be heard and right to be reasoned decision. A conviction, if it is completely based on an unexplainable AI, or a conviction if court can convict a person just because of the black box problem, or AI models, which is not explainable, the output which are unexplainable, given by the algorithm, right to reasoned order in principle. That's why I mentioned that whenever we talk about the admissibility, there is an implicit about the constitutionality. Another slide, what counts here about the AI is concerned, it's not a one thing. I mentioned about the three things, each of it has some evidentiary logic. AI as an author of the evidence, AI as an analyst of the evidence, AI as an assistant in adjudication. These are the three roles which currently performed by the AI in the judiciary. First, AI as an author, it means the content is generated by a model, but that content must be you are producing in a facts issue. what AI is produced. For example, your deepfake video, synthetic audio, AI fabricated documents using ChatGPT. Very great example we see in the Meta versus Avanza. Number of the citations are generated by the ChatGPT, which is a violation of the professional misconduct. Another class or role, AI as an analyst of the evidence. It's the real primary evidence which is processed by AI system. I mentioned the process. So the model, interpret and classify. So here, role of AI as an analysis comes in facial recognition match, biometric, AI enhanced CCTV footage, algorithmic handwriting comparisons, where AI can play an analysis role. Third is AI as an assistant in adjudication. Here judiciary came. So AI is aiding, they are helping the court or even the counsel. For what? Just to shaping the record. That's why you can see the Supreme Court of the India, for their regular business tasks is concerned, they developed a SUPACE, SUPAC. SUPACE is one of the research aid platform. Then SUVAS is one translation platforms to convert the documents in their regional languages. Print to risk scores. These three roles which AI can perform. Means AI can do an author, but can we say AI is a legal person or as a jurisprudential speakings are concerned? That is also one question. AI do analysis of the evidences. Sometimes what happens as a day-to-day routine task, maybe sometimes you can directly put a brief in the chat GPT and you can mention kindly analyze and declare who is one in this case. It's completely not allowed. It's a misconduct. You don't depend on AI. AI can make mistakes. Even that model can assumption, this platform can make a mistake, kindly verify, but still you are not in a position to verify. We are so handicapped, we completely depend blindly on the AI model. Single minute you can put a prompt and got an answer. To some extent it helps, but unless until your human reasoning is most important, your rational mind is most important, human should be required in the loop. And that's why every guidelines which came, the judiciary won't mention the judges are the ultimate deciding authority, but judiciary also must keep a watch. We require such a kind of a system which they can understand whether the brief which are submitted by the lawyers or what are the evidences which are cited by in the brief itself, citations, case citation is really trustworthy, genuine or fabricated or manipulated. There's no such kind of a system yet. We just cross-verify by checking some of the other platforms. This is also one of the point. Now here I mentioned some practitioners kit from document to deepfake, because we are currently maybe we are living in era of a deepfake. Where does the exhibit use it? Exhibit, suppose you are citing an exhibit of a CCTV footage or call records, mostly in the matrimonial divorce cases. So maybe husband or wife can record secretly a voice of the husband or the wife, either one of the party. Maybe in case of the corruption matters, CDRs can be produced, call detail records can be produced. Maybe in some place CCTV footage can be produced. So nature is, it's a machine recorded, it's primary. But which provisions are applicable here? Again, section 63 BSA, which is previously a 65B of Indian Evidence Act. What the risk to address here? I mentioned a certificate, you require certificate plus integrity of storage. I will come to that point in more detail here also. Then if any CCTV footage, I mentioned AI enhanced, you are producing CCTV footage or any audio, again it's a machine processed. Again, the same section 63 BSA plus section 79 of IT Act, because you require certified examiner. Again, facial recognition match is concerned, algorithmic opinion nature is there. You require here section 39 of BSA, which is an expert opinion, previously section 45 in the IEA. So here what maybe chances are, there's a false match rate also. There's a false match rate as a demographic biasness are concerned. In deepfake video, it's a synthesized media content. You require section 63 BSA plus section 39 of the BSA, which is expert opinion. Then detection is most important. Then large language model, LLM generated text. Most important is originally it is inadmissible, but because it can generate a falsinated, fabricated idea or content. So these are the what document to deepfake, where it sits, what exhibits required, what principles are required. So the certificate under section 63 clause 4 clause C of the Bharti Sakshya Adhiniyam, they at least authenticate the file, but question is still remaining about the content of this file. Both are usually needed. But when AI is in the chain, that challenge becomes more strong. Now here I mentioned one of the case, your facial recognition from CCTV footage to conviction. high cost, very low we can say explainability. 2020 in Northeast Delhi riot case, where the Delhi police they deploy the FRT, facial recognition technology, in over 750 investigations from the Northeast Delhi. They identify matching CCTV footage frames against driving license or Aadhaar link database. But the confidence threshold as low as 80% below any published operational standards. So mostly there is a chance of misidentification. Even in the Jantar Mantar currently student protest also, maybe no one can know, but they can deploy this CCTV FRT deployment. But there's a misidentification, chances are more also. That's why students are demand to take the offense back. There's no FIR, no anything are there. Even the students are silently protest. So this is also one of the angle. So questions can came for the courts. Courts have to speak. Is the facial recognition technology match itself is evidence? Or it's merely only investigative lead? Can we say the algorithm training data is disclosed to the defense? How it can be disclosed? Maybe in future lawyering, in future courts, it may possible the opposite lawyers or opponent defense counsels can demand. One is which kind of the algorithm data can be used? What is the threshold for admissibility? Does Puttaswamy require a court warrant before a FRT search is concerned? Is a facial print testimonial is a testimonial, non-testimonial under Article 20, Clause 3? So this is one of the example. And if you want to cross-examine the opposite lawyers, they can use their parties by the court side, government side. The cross-examination checklist includes, you can directly ask which vendor, which model you are using, which video, which version, what the confidence score. You can directly attack particular way. Whether any human reviewer is involved, chain of custody of this TV feed, whether there is an independent studies happen on this technology or not. This is also one more aspect. Now come to the most important point about the one subject foundations. Three important provisions, they touch the AI touch exhibit, even the record. Your 65AB of the previous Indian Evidence Act, Section 63 of the BSA, with the schedule which is attached with the new law, then IT Act, particularly Section 79, which is the examiner of the electronic evidence, examiner of electronic record. But apart from, there's a more important role currently about the intermediary guidelines also. That also mention about the particular definition of the synthetic media or AI-generated media. Just, I hope I'm audible to all and the slides are visible.
Yes, sir.
Yeah. Just glimpse about the older of what Section 65A and 65B. Maybe some of you also produce this kind of a certificate in the courtroom when you are submitting any call detail records, when you are submitting any kind of electronic record, either that record in the form of a CD, pen drive, or any storage devices, either in the form of a computer output, maybe in the form of printouts. You have to submit that particular certificate, famously known as 65B certificate. This is the old regime. It's a self-contained code. So what Section 65 talks about, it's an admissibility of the electronic record in the court. But the procedural aspects mentioned in Section 65B. Particularly in Section 65B, Clause 4 deals with the certificate. So this section is inserted actually when IT Act 2000 is there. So the four important conditions are there in this particular Section 65B. When you want the court can admit my electronic record as an electronic evidence, your record must satisfy some conditions like from which computer you are taken, that record is regularly usable or not, whether it's under the lawful control of a person or not, whether the information which are feeding to that particular computer or the device or any communication device is regularly fed into that computer or not, whether it is operating properly when during that period, during that duration, when you are taking the output, either that output in the form of printouts or maybe in the storage with the sum of the device, whether that computer is operating properly throughout that period or not. This is the most important condition. Then and then your record can be admissible in the courtroom. But for that purpose, the judges, the judiciary must be understand the various nuances of this old regime with the Section 63 as well. So what the previous, our old Indian law, Indian Evidence Act, that Section 65A and B, they are completely model on the UK Civil Evidence Act 1968. That is completely depend on the Britain's Civil Evidence Act. But now we are repealing earlier Indian Evidence Act with the Bhartiya Saksha Adhiniyam, as there is no so much changes done with this Bhartiya Saksha Adhiniyam. Only there is a increasing the section numbers from count from 167 to total 170 section with one schedule is attached. And there's some changing arrangement of the sections in the Bharti Saksha Adhiniyam. But whatever the changes is there, it is only about the electronic records. That is the what new code about the Bharti Saksha Adhiniyam is concerned, which forced from 2024. What changed actually? They change what the 4 conditions which are mentioned in section 65 BYC similarly mentioned. The same conditions are still remain same. They survive in section 63 clause 2. It reproduced the verbatim of the old section 65B clause 2, means regular use, regular feed, proper operation, faithful reproduction remain the same. But what in the earlier law, in what format, when any party want to submit the electronic record in the courtroom, which format of certificate they want to produce, not mentioned. So any certificate that problems can come in the old law, that problem is overcome by the section 63 in the new Bhartiya Saksha Adhiniyam. They provide one schedule, it's attached, and that schedule is talks about even format of a certificate under section 63 clause 4 clause C. And they provide a dual or 2 parts of a certificate that requires that certificate by 2 parts. One part, both parts must be with signature, but the part A and part B, the part A must be signed by the person who is in charge of that system or the device of that or that computer. And another part B is completely signed by the expert, the responsible operator. So the schedule prescribes not only certificate, but in the certificate itself, they provide a hash value. It's a digital fingerprint, I can say. It's an expert mandate to provide a hash values with some algorithm. It's a digital fingerprint of the file to maintain the integrity of the records. So the broader intake is there in section 63. The computer, not only computer they use, but they use the word communication device. So and the records held through an intermediary as well, that also come. So they include the platforms where cloud platforms also includes in this way also. I hope am I audible clearly?
Yes, sir.
Okay. So this is about what section 63 in the new law. Now, what important changes happened? The electronic records are now a primary evidence. So in the old law, in the Indian Evidence Act, the most important consequential change happened. There is a section 62 and section 63 in the old law talks about definition of primary and secondary evidences. But in the recently, when the Bhartiya Saksha Adhiniyam which came into force from 2024 and passed in 2023, they added certain explanation clauses in section 57 of definition of primary evidence, which is originally section 62. And they directly mention in some circumstances, those electronic records become say primary evidences. Because before Indian Evidence Act, it becomes secondary evidence. Means your printouts, media copies, records on computer output. So it should be required signature on your responsible officers, even emails and say emails or CDs. But after BSA 2023, electronic record becomes primary evidence. Section 57, they expand the definition of primary evidence. They include explanation 5 to 7 under section 57, where they includes automatically your cloud data, semiconductor memory, communication devices, all captured becomes primary evidence. Certificate must be countersigned by the expert. Hash value is mandatory now. Why hash value is mandatory? Maybe you know that what the hash values are. I will not go in technicalities, but the hash value for the purpose are to maintain the integrity of the records. So this section 61 is clearly mentioned, technologically neutral. They mention there's no inference of inadmissibility on the ground, that is electronic one. They prescribe the format now. So in that format, you can submit any electronic record if you want, your record becomes an evidence. So schedule is in the prescribed form is given by the new law. That a template is given, hash algorithm, device details, custody log, all details can be mentioned in the particular certificate. Now this is what practitioner must know. Whenever you got some kind of a brief with you about any where your information is available in electronic form and you want to submit in the courtroom. So you must know the 65B in the old law, because old cases are still running under the old law. The new cases are still under the new law under section 63. So if you see in the both comparison perspectives about section 65B, so scope of this source is only about the computer that time, but in the old law, in the new law, I can say not only limited up to computer, but also includes a communication device, which includes the intermediary, also record and cloud platforms and everything. Then certifier in the section 65 old law, only responsible official position, single signature is sufficient. Moreover, no format is mentioned. So whatever format is given by the any forensic expert or the person in charge, that can be admissible. So there's a dilemma. The confusion is there. But in section 63, completely two signature format of certificate is given. Even hash value previously not mandatory, but now it's mandatory. Part A, Part B format is given. So whatever, if you see the case law status of this, that previous law and the current law, the current section 63 is actually a modification of what the Supreme Court of India given the judgment decision in Arjun Panditrao Khotkar case that codifies section 63 in the current BSA actually. This is very important one. It's a textually modernized what the electoral record to be admissible in the courtroom. This is also one more you must know about the some sections and that what the electoral records to be required. So section 79A, which deals with the examiner of electronic evidences, because this section 79 is clearly mentioned, the central government will notify the who will be the panel on the examiners are concerned. So mostly those are some notified lists are already there, like cyber forensic divisions, particularly CFSL Hyderabad, Chandigarh, Pune, Delhi, Kolkata. Then state officials are concerned, CDAC is concerned, maybe mostly these are the West Bengal laboratories are concerned. These are the some regional central forensic laboratories. They can become notified on 8 August 2023 as an examiner of the electronic evidence. And why it matters for the AI, as per our topic AI is concerned? Because the section 63 clause 4 clause C of the BSA, where experts signature is concerned, it pairs with section 79A of the IT Act. So even though even your AI evidence are there, AI generated fabricated evidences are there, you require section 63 79A. So notification is mandatory before a lab can render a competent opinion. So practical point is kindly verify the notified status about the accreditation of that notified examiners are concerned. So this is also one more unbroken chain from Caesar to courtroom. It's not, I will going to go for technicalities, but as a chain of custody is concerned, I hope everyone maybe heard the chain of custody while your practice is concerned. So naturally, in case of the any AI generated evidences are there, or you want to submit that record in the courtroom, so there are steps like Caesar and imaging. These are some technical and scientific words, like you require bit by bit forensic imaging with some tools, right blocker tools. They compare the hash competencies also. Then it can be sealed in the paddy bags to avoid the magnetic flux also. That can be properly sealed with storage, and every access can mention the COC form, chain of custody form, date, time, purpose, which officer is handling. Then the work analysis should be there on working copy, not the original. So original is untouched always. So all whatever the AI or forensic tools are there, they can be run on duplicates, mostly the working copies. And again, there is a rehash if you are before producing also. So court receives the file which is recomputing the hash and which matches the certificate. That record can be produced. And if any link is broken in between this, your weightage of the evidence is collapsed. This is what in general, in very brief, I trying to avoid the technicalities. These are some kind of the chain of custody from Caesar to courtroom. 4 judgments are there from 2005 to 2020. It's a doctrinal arc which required every advocate must know. Navjot Sandhu's case, then Anwar's case, Deshafi Muhammad, then Arjun Panditrao Khotkar case. So the certificate, the parameter is about the certificate. In Arjun Khotkar case in 2020, Justice Nariman talks about the certificate which is under the current section 63, but previously section 65B clause 4 is a condition precedent, is required. When you produce any kind of record in the court, must be required. So here, one by one case law, I will be very fastly will taken about the parliament attack case, Navjot Sandhu's case, Afsan Guru case, where the parliament is attacked in 2001. So the whole case is rested on mobile phone call records. So they tender the computer printouts, but while submitting the computer printouts in the courtroom, they not submit section 65B clause 4 certificate. which is mentioned under section 65B clause 4. So that even in this case, the electoral records could be proved as a secondary evidence. They proved under section 63 of the old Indian Evidence Act without compliance of section 65B. So in this case, Navjot Sandhu's case done an error, which the modern rule is completely taken away. But between 2005 to 2014, Indian courts admitted CDR secondary evidence. Every 65B, 63 argument today begins with the memory of this permission era. But the same case of this parliament attack case is overruled in the Anwar case, 3-judge bench versus Bashir, where it is an election petition, which the petitioner is produced one audio CD of, and they produce the 65B certificate with CD also. So the court previously relied on Navjot Sandhu's case, but ultimately the court can overrule previous parliament attack case. And what the ratio or the main principles came here, they mentioned that time section 65B is a complete code, mandatory, it's required. All conditions which are mentioned in section 60, it is mandatory, it's a condition precedent, certificate is required. So Navjot Sandhu is overruled. So in this paper, the purpose is to sanctify the secondary evidence in electronic form. So any documentary evidence by way of an electronic record under the Evidence Act, they must see section 65B is a complete code and kindly produce the certificate is completely mandatory. But again, in 2018, Shafi Mohammed versus State of Himachal Pradesh, again the 2-judge bench changed their own stance. What in 2014 Anwar case is mentioned, the condition is important, 65B certificate is compulsory submit when any party want to submit record in the courtroom. We cannot accept the record without certificate. Same court, Supreme Court of the India in 2018, in Shafi Mohammed case, where the question issue is about the recordings of the police investigations came into limelight. It is required to video recording of the crime scene is required to inspire the confidence of the public as per the police investigations are concerned. You can see this is the case which in the BRSS mentioned there's a compulsory videography of a crime scene. Because in this case, the issues came about the videography of a crime scene is required or not. Because general perceptions about the public is that the police is not doing a proper investigation. Can we, every scene of the investigation can be videographed? That questions can come in Shafi Mohammed case. So following Anwar, the trial court routinely refused CCTV footage also, WhatsApp screenshots and voice recordings. When the party could not produce certificate, they cannot do. The court in this case can waive, not require the certificate they mention. They mention it is interest of justice. In Shafi Mohammed case, they mention the applicability of the requirement of a certificate produced, it relaxed in this case because it depends on the interest of a justice. So the major premise of the Shafi Mohammed is unfounded, but this case is also overturned in Arjun Khotkar case. Now this is a very important case about the Arjun Khotkar versus Kailas Gorantal, where in this case, Anwar case is again reaffirmed. Certificate under 65B clause 4 is condition precedent, important for admissibility of records. Shafi Mohammed is overruled. A two-judge bench did not override 3-judge ruling. It's a procedural relaxation is bad law then. Court complaint power. When certify refuses, the party may apply a court for summon. Certify cannot become a escape hatch then. So reform is required. Court invited the legislature to modernize section 65B, and that's why to modernize section 65B is nothing but the seed of the section 63 of BSA. This is the most important. This is a major premise of Shafi Mohammed is unfounded, cured by the Arjun Khotkar case. This is also what I mentioned, ChatGPT enters in the courtroom. Jaswinder Singh was State of Punjab, 2023 case. Here, second bail application in a case, particularly very brutal assault which causing death. The judge at the end of his reasoning, he put a question of general principle to ChatGPT. What is the jurisprudence on bail when the assailant have acted with cruelty? Now what the questions, what I can say here. So first recorded reference is a generative AI chatbot by an Indian court in this case. They used a illustrative global perspective. Bail was denied. bail was denied. So AI reference how till the outcomes. Court expressly disclaimed the reliance. And that's why they mention, kindly see the recently Kerala High Court AI policy for the district judiciary as well. So any reference to ChatGPT and any observations made herein above is neither an expression of opinion on the merit of the case. This reference is only to present a broader picture on bail jurisprudence. But the cautious approach is the order is not an authority. When what an large language model says, it is authority for how a judge should frame such a assistance use. No. So citing a chatbot output in your submission, you carry what the one of the case Meta versus Avansika. Risk is there. Always verify your primary sources because your conviction acquittal depends if you're using a chatbots or anything. Never cite AI as an authority. One more important section where the pleading is authored in part by ChatGPT again. I want to take this because you are the future lawyers. Number of times you are using it as a court ethics demands. Home Buyers Association versus Union of India, a writ petition which is filed by the Home Buyers Association. They cited 4 landmark precedents, including one is Supreme Court on RERA, but when the counsel opposite lawyer can search, that case law never exists. Even the other party can cite with paragraph numbers, with judge's name, with reporter references. How we can say about that way? So each and every ground is a false and fabricated and AI generated. So petition was withdrawn. And the court mentioned ChatGPT cannot be the basis for the adjudication of a legal or factual issue in court of law, because AI output is not verifiable. Even AI models in models can mention AI can mistake, can't verify. Still you can blindly accept. So advocate has an independent duty to verify, not delegate the task to the AI model to do anything, because filing hallucinated, fabricated citation is a breach of the officers of the court obligation. It's a potential contempt, I can say. So maybe in future contempt of court act can be amended and they can use one of these particular filing or citing a hallucinated, fabricated AI citations. You become liable for the contempt if it can be verified. This is one of the another case, Anil Kapoor case. You know that one of the 16 defendants can be website operators. They misuse the signature catastrophe of the catchphrase of the jackass through GIFs, and they use AI generated deepfake content endorsement. So their recognition of persona is important. Personality rights came into limelight here. Not only Anil Kapoor, all celebrities can come into limelight. So Denmark is a country, they provide a copyright to all their citizens in the Denmark. If there is a defect, they can be prosecuted. So personality rights meet the defect now. Rajesh Sharma's case, same thing can be happen. It's an unregulated defects. Delhi High Court dictated Union of India to nominate some member committee at least. That's why currently the committee is established. So why it matter? Because judicial acknowledgement that exists in IT Act, IT rules, they are insufficient to police AI syntheticated media. Delhi High Court created a court supervised committee here currently. In Rohilla's case also. We require complaint of MIT. They issue guidelines also. So these are also very important platforms. If you see the comparative aspects, I will mention some Roberts and I will not go Daubert. See, mostly Daubert in the American case, they laid down the admissibility of the expert testimony actually. But they mentioned some guidelines where how we can give more, how much weightage should be required to provide expert. Daubert case is there. They mentioned some factors. They mentioned that the expert evidence must be admissible only if the technique which are used by the expert is it testable or not, is it peer-reviewed or not, what the error rate is there or not, what generally accepted in the relevant community or not. But ultimately, judges are the ultimate gatekeepers. That's why Rule 702 of the Federal Rules of Evidence in the America, in the USA, just like we have Indian Evidence Act, they have Federal Rules of Evidence. Their Federal Rules of Evidence, Rule 702 mention expert testimony must raise sufficient facts. But currently there is a proposal. There is a proposal on Judicial Conference Advisory Committee in May 2025. In Congress, they propose a Rule 707, which they can mention machine as an expert now. They want, through this conference, their submission is due to Congress, machine-generated output offered without accompanying expert must be meet the Rule 702 standards. And that proposal is in the Congress itself in the America. This is what number of times which I mentioned this case study is a hallucination meets sanction. This is one US District Court case, Mata versus Avansika, which is mentioned in this personal injuries case about the airline plaintiff. Their counsel is mentioned. There's an affirmation in opposition. They cite 6 precedents. They cited 6 precedents, and all are fabricated by ChatGPT, means not exist. They complete with the fake case numbers, quotations, paragraphs, cross citations. So the court imposed $5,000 monetary penalty against these petitioners. So they mentioned, the court is mentioned, the technological advances are commonplace, but they cannot accurate. This is what the questions came. Next case in particular, Britain, Bates versus Post Office, Horizon. Horizon is one of the AI model, AI tool. Why I am important? Because we are using number of models currently. From 1999, UK Post Office, they prosecuted some sub-postmasters because they flagged by Horizon. Horizon is a one accounting system. Horizon is a one accounting system. The conviction is rested on the common law presumption that whatever the computer is doing work, it is correctly. This is a presumption unless contrary is shown. So there is 900 plus wrongful convictions only about this Horizon accounting softwares. 20 years is the scandal. 2024, then Horizon Offences Act is quashed convictions. So what are the presumptions are mentioned? That the computer output is operating properly. It's a fiction. Because AI proved evidence. Did the model behave as a design? No. There may be a problem in the error in the accounting software, maybe in the AI model, and you can completely write. It's a dangerous thing. Here I mentioned a risk AI Act. European Union is very important. Their European Union Artificial Intelligence Act is there, and that act is completely based on 4 types of a risk. I will not go in more detail about the risk, but they categorize into unacceptable risk, high risk, limited risk, minimal risk. So what direct relevance in evidence is concerned? They are compared with the GDPR, General Data Protection Regulations. Very strict Artificial Intelligence Act is there. They are adopted by the Parliament and Council, entered from 1st August 24. They completely prohibit the AI bans, and there's a most high risk regime in the European Union. Singapore is rebuttable presumption, means there's no mandatory certificate is required. They clearly mentions there's no presumption that computer always operate properly. There's no device operate properly. When record is produced by a device that appears to have been operating properly, but the record is not, their record is presumed to be accurate that time, but they're not accurate as per the Singapore. So electronic signatures. They introduced the Evidence Amendment Act 2012 that deliberately shift the admissibility from procedural to the substantive evaluation. Very, very good, I can say, about the Singapore rebuttable presumption. These are about the whole what we are learn about the where India sits and where we are going with compared to aspects are concerned. So naturally, India we have a own code of law, that is mandatory certificate is there under section 63 BSA, formerly section 65 IEA, dual signature format. Next, reliability test is what? Till judicial appreciation. Till judicial appreciation with section 79 of IIT as expert opinion. AI specific rule is concerned in India, none yet. I still mention there's none AI specific rule is there. We are ruling under this BSA with IT rules, most important, and the judicial precedent. So India's answer is the stricter at the door level, but the European Union is the most demanding of the system, and America most searching of the expert. So each has some incomplete answer to the AI question. Emerging challenges, very important. We are learn the statutory frameworks. What as a advocates is concerned when you are come with such a kind of a case brief which involves some electronic record, audio, video, image, multimedia files, any, and you want to submit that record in the courtroom. So these are the statutory frameworks like section 63 currently with certificate is required. But currently what challenges are there? I categorize 4 issues. That framework of 1663 was not written for that, as I personally feel require more amendments. And currently defect wave is number. Most important, liar's dividend. I will talk about the very important parameters currently, even the NEET paper leak case. Black box problem is we are facing an authorship of section 63 gap. Synthetic media wave, I just mentioned a synthetic media wave is there, docket has not caught up. Okay, 2,137% deepfake share or fraud, rise in 6.5% more. See, 4x years on year growth is there. I hope slide is visible and am I audible to all properly?
Yes, sir. Yes, sir.
Yeah. So there's a 4x year on year growth. Every 5 minutes, there's an attack interval in 2024 globally. Up from 5 lakhs to 16-fold jumped in 2 years. So why this mean? Because for every 100 electronic evidence disputes which are filed in 2020, expect growing share of a synthesis question. Mostly, which are the cases? Matrimonial audio recording. Sometimes the wife or the husband, they can record. Family disputes, matrimonial audio recordings. Extortion voice notes, mostly in corruption cases as well. Defamatory videos. In endorsement fakes, check image manipulation, KYC bypass. Then comes your problem is about judicial capacity, expert supply, and forensic accreditation. That is ahead of the view, not behind it. Now, this is the most important point. The liar's dividend is a denial of weapon. It's a denial weapon. Means when your real evidence can be dismissed as a fake. Liar's dividend is a socio-political concept or phenomena. It is coined by the Robert Chesney and Citron. They mention it's like a public, sometimes more public awareness about the deepfake, about the AI area is concerned, synthetic media, it grows. That's why sometimes wrong doors gain a defense. Wrong doors, which is wrong door, they got a defense. What? That is a AI video. It's just an AI fake. I will link this liar's dividend in the current NEET paper leak case. And I hope maybe you understand this. See, sometimes what in the NEET paper is leaked. It can be available in some platforms, social media platforms. And really it's a genuine. And the students, they are really producing the evidences, real evidence, genuine evidence. They show the video, they can show the PDF copy, how it can be spreading through the WhatsApp, through the Telegrams and other channels. The really evidence is there. They're showing to the government also that there is a paper leak is there. Kindly there's a do investigation, do the particular legal angle, do the investigation, do the proceeding for the particular investigation. In this case, even though sometimes government authority, at least the functionaries, they know that it's a genuine, real evidence, but it's a liar's dividend. They can mention, no, it's the video or the copy show is a AI fabricated. It's just an AI video. Means when real evidence can be dismissed as fake, because there's a more awareness that when you can see in the Instagram also, when in the reel came, you can say it's AI edited, it's an AI video, it's an AI image, it's an AI reel. Maybe sometimes 2 days back, what our Honorable Prime Minister got the time to interact with the students on the Instagram reel at the evening night time, but not physically come to meet the students at the protest on the house, they are in front of their house also. Questions can come. Maybe it's not his own voice. Maybe it's a AI video. Means more public awareness. Sometimes more public awareness about the deepfake. Maybe some highest official, public functionary. Maybe anyone can mention. Even though it's look at genuine, it's a genuine video. It's a real evidence. But you mention it's an AI video. It's AI fake. Means it, but you can directly mention it's a liar's dividend. Wrongdoer can gain a defense. The authenticity of the genuine evidence is corroded not because of technology, but because it could have been. Because every screen becomes a suspect. Where India is seen it, you can see in 2024 gender relation cycle. Multiple candidates disown authentic audio video clips. Even though suppose any audio video clip is captured, you are producing before the election commission, you mention they violate the code of conduct, kindly cancel their candidatures. Even though that particular candidate, no, it's my genius, it's real video, but he can mention, no, it's a AI video, AI fabricated just to harass me. So more awareness can you take a defense, it's a plausible defense. Even in case of the matrimonial and commercial disputes as well. Party challenge, real voice.
So, are you there?
voice notes and producing in the courtroom.
So your voice and video both are hang.
So, and advocate or future education, they should because there are other side.
Rahul, so sorry for interruption. Can you please check your internet connection? There is a sound break.
Next challenge, black box. Am I audible?
So your voice is
No,
breaking
sir.
again and again, sir.
Okay, now it's audible.
Yes, sir.
Yeah. Now next challenge is section 63, authenticate the file, which I mentioned from very beginning of the lecture, not the content. That is also one more challenge which is required to be cured. Because what section 63 clause 2 actually asks, was the device is regular use? Putting properly. Does the audio really faithfully reproduce what it is? Each of these
Sir, again there is a voice break. We can't hear you.
exhibit which match the byte sequence. It's a very question. But what bit of CD match that sees from the accurate phone? Hash value can be verified. The certificate is correctly issued. No doubt, section 63 is certified. But what the video itself may still be entirely synthetic or not. The model output, that is a very important challenge. So here a 10-point authentication checklist when you come up with the particular AI generated evidences are concerned as an advocate's point of view. So before the certificate is concerned, kindly see, secure the original device. Some memo, write down in memo, hash a scissor memo, never rely on copies alone. Second, compute the hash value. I will hash value. These are some technical terms. When I got the times, I will go in more detail that way. Then preserve the metadata, timestamp, tower location, everything. Identify the certifier. Then if AI is in your chain, if AI is in the chain, then disclose the AI tool. This is most important. Disclose the AI tool, model name, developer, version, everything. Then retain their logs. Then use section 39 BSS expert opinion. It's an opinion. Always remember, it's an opinion. Document the whole chain of custody and list the experts on the witness role. This is a very important 10-point authentication checklist for the advocates while handling AI generated evidence. It's a practice kit while tendering the exhibit. These are the cross-examination. This is directly attacking the exhibit here. 6 heads. These are the cross-examining the AI witness. First is you directly ask where the file comes. You break the directly ice here. Scissor memo. What tool, what version, what model, what is the potential error rate? What is the competency of an expert? Was the system is healthy? Or whether that particular AI model is, they are somewhat to be a ambiguity, they generate output differently. Is the file itself a synthetic file or not? How much detection rate is there? These are the cross-examining questions in digital evidence is concerned as an AI witness. So this is also one practice case as an ethics at the bar. I hope slide is visible to all and am I audible?
Yes, sir.
Okay, so using AI in your practice, the duty of a candor is very important. Existing duties as far as the BCI is concerned, your duty is towards the court. What advocate shall use his best efforts to restrain and present his client for unfair practices in relation to the court. This is also most important. But as far as some 5 practical rules I mention here as an AI assisted practice, because in future you are doing practice in AI assisted mode. Because court are also moving that way also. So accordingly, you have to amend, you have to add the duties. Practical rule is verify every citation. If your research surfaces only case, pull the primary source. This is the most important conduct. It's a violation otherwise. Next is never plead AI generated facts. Use large language model only for drafting hygienic grammarly purpose, not judging for the whole brief. Next, third is protect the client's confidentiality. Here, don't put directly the brief in the ChatGPT or cloud or to the models, and models can use those names for training their purpose. Fourth is disclose vain material. Means if AI produce significant part of your file, otherwise you can suffer the penalty. Next is last, retain paper trail, prompt, output, timestamps, because next maybe in the advocacy rule in practice, every advocate must learn, must know. I think India should go. First, it's a modest but urgent proposal. First is there should be required an explanation in section 63 BSA, which directly mention AI implicated exhibits, which directly mention disclosure of model is required, inference log is required, as per the European Union AI Act. This is my proposal. It's urgent. Next is the at least one defect competent notified examiner is required under section 79 as an examiner of electronic record. Third is pan India Kerala style AI policy is required. You go through the Kerala AI policy, which is laid down by the district judiciary. They completely ban the AI legal reasoning. They only mention AI should be used for assist, not reliance completely. Disclosure by judge is required if AI touch the reasoning. So a pan-India Kerala style AI policy is required. That's why currently the use of AI draft regulation is submitted for the suggestions by the government. Fourth regulatory framework my proposal is there. Enact the draft IT rules amendment in 2025, which is now recently mentioned. There's a mandatory labeling of synthetic media. They are recently mentioned also. Means when you put, you must mention is AI generated or not. Most important, maybe your honorable bench is also there, honorable members of the bar is also there. A BCI advisory on AI use in practice. Recently, they used some social media for ethical code of conduct for the lawyers and advocates, but they require more ahead. Mandatory verification is required. Currently, mandatory verification of AI surface authorities database is not there. Disclosure of obligations where AI produced the material position of filing, BCI is required to take an action. This is a modest but urgent proposal from my side. Another proposal is there. A DPDP compliant, we know an amendment is required, but that amendment must be with goes to GDPR. A right against adverse decision. Strength of AI output is most important. These are the 6 proposal, but urgent proposal as far as the AI, if you want to overcome the citation of the AI evidence is concerned. And in conclusion, the certificate is only the beginning. Even the what section 63 is does not mean the section 63 provide a license to produce any AI output with certificate. No. Because questions can come, did this file come from the desired device? But the AI poses a different question. Did this content come from the human or not? Authorship is important. So between these two, the practitioners must build the bridge between this particular gap. Here, I hope my slide is visible to all. Yes, am I audible?
Yes, sir. Yes, sir. Yes.
Yeah. Now, here I mentioned, read this line, the constitution does not need to be rewritten. But in our context, imagination of evidence does. What Anwar and Arjun Panditra Khotkar, they are the constitutional floor. Certificate is not a technicality, it's a mechanism. Section 63 BS is a beginning, not the end. And judge remains the ultimate authenticator. Always remember, this is the most. An algorithm may inform, but it may not decide. Gujarat High Court's line is there, is right. AI helps, but humans judge. This is the most important. So the technology without law is anarchy, but the law without technology is irrelevance. Okay, the task is of our generation, our practitioners, is to reconcile these two, technology with the law. They go hand in hand. So this is from my side. As far as in the short span of time, I try to cover all the nuances about when any party or any advocates, if their case brief revolves around, the electronic record, so how they can go with these particular sections about the IT and section 63 and all those rules are concerned, how they can submit it, which of the formalities are required, and when AI is also there, so how they can handle it. So if any questions are there, I try to answer all queries.
Yes, so thank you so much, sir, for your engaging session. So give me just 2 minutes to modify the settings and then we can directly start with the Q&A. So this
Yeah.
is just an information for all the attendees as well. We'll take the first 5 questions because, sir, we've already exceeded the time. So I request all the participants to be as concise as possible so that we can handle all the questions, right? Give me a minute, sir.
Yeah.
Yes, Govind, sir, please ask your question.
Hello, sir. Hello.
Yes, yeah.
Hello.
You're audible, sir.
Hello, sir. I'm going, sir. Sir, suppose the case is filed in 2023 and recording is of 2021. Under what section we have to provide the certificate? Whether we have to go for 65B or 63B? 63.
When your case is filed?
Filed in 2023.
2023.
And
Okay,
video recording is of 2021.
There's a much lag is behind them actually. It maybe court can demand, maybe court can demand section 63 also. Your recording is in the 24, na? Your recording is in the 24.
No, recording is of 2021.
2021. Recording is from the 21. You are 65.
65B. Okay.
Yeah.
Thank you, sir.
Yeah.
So there was this one question which was asked by one of the participant, whether certification under BSA hash value needs to be given. If not given, what is its effect? And is there any case law in regard to this?
Yes, hash value is mandatory because the two part of the format of certificate itself is mentioned in the format hash value. And they mentioned the SHA secured hash algorithm 256 and all those mention you have to check box it. So hash value is required because to maintain the integrity